All right, guys. So we want to welcome you to our third AVE event, and this time featuring the attorneys, the lawyers. In a couple of minutes, I'll be handing it off to Javier Perez-Abreu, class of 75, I mean 78, sorry, and he'll be moderating today's event. But I wanted to first thank them. Fernando Aran from 75, Javier Perez-Abreu 78, Sergio Mendes 77, Jordi Guso 1983, and then Javier Basnuevo 05. Last week we started with a prayer, and this week I'd like to start the off the same way. Uh, in the name of the Father, the Son, and Holy Spirit, Amen. On Monday was Rick's 47th birthday, and I want to pray for him and his family, and for what they're going through, and the repose of his soul. I'd like to pray for all the families that have been going through tough times with COVID, our community, the panelists, the alumni, and and then for this to end soon. All right. So in Jesus' name we pray. Amen.
Amen.
Amen. Father, Son, Amen. All right. So I'm gonna go ahead and hand it off to Javier Perez-Abreu. But before I do that, just a couple things. Please, we have you on mute. We will have a chat going. We've received some questions from you before already that I've passed on to the attorneys. Any other questions, please feel free to hand it over to the chat, and we'll take it from there. I have Jose Lopez, Pep Lopez Varela, also helping me out, so we'll be doing that. At the end, we have a survey for you to fill out. It'd be great to see some feedback from you guys, and that's it. Next week we'll be having another AVE with the accountants, and you'll be getting information on that as well. And so that's it. So with that, I let Javi take over. Thank you, Javi.
All right, thank you, Carlos. Thank you very much, and thank you for those kind words for Rick. Obviously, he was a very well-respected brother, and we're gonna miss him. Regarding our chat today, we first got to do a little general disclaimer. Although we are lawyers and we are trying to give you guys as much information as possible, obviously this is a general discussion for informational purposes only. These are new cutting edge issues and hot topics, and this is no substitute for proper legal advice. So please do not rely on the information that you are going to be hearing today. We suggest that you consult with your attorney and get the proper legal advice. So with that, for those of you that don't know me, Javier Perez-Abreu, class of 78, politely known as El Gran Huevón in the balls section. I am going to hand it over. I'm going to introduce the speakers, or they're going to introduce themselves in order of seniority. So with Fernando Aran, class of 75, he's going to give a brief intro, and then we are going to start our discussion.
Folks, glad to be here with all of you. As they told you, I graduated from the class of 75. The best homeroom class ever was the 9B Bruins, and our homeroom teacher was Pat Collins. I'm brown-nosing a little bit. I've been practicing law basically for a better part of 38, 39 years. I had the pleasure of going to another fine Jesuit institution for law school, Georgetown. Spent a lot of time in my early career litigating, being a trial lawyer, and the last 10, maybe even 15 years, I've been doing more real estate work and just office corporate work than litigation, so I still litigate a little bit. And I will be giving you a quick 10,000 feet overview of the Paycheck Protection Program. That's the PPP loans, and I'm going to concentrate more on guiding you through what the forgiveness is all about rather than the application process. But there it is.
All right, we got, I think Sergio's next. Do we have Sergio?
Yes.
Okay,
yeah. Boys, I graduated in 1977. I'm having something on my, okay. Can you hear me?
Yes.
Yep. We can see you now.
1977 from Belen with Fernando and Javi, and back then it was such a small school that we had the benefit of all being together and sort of mesh into one class, which was great. I've also had the benefit and honor to have both of my boys attend Belen. Louis graduated in 2005, and Daniel graduated in 2007. And Daniel's my managing partner here at the firm. We concentrate on probate, trust, and guardianship litigation and some administration. I've been practicing since 1985, and I'll be addressing topics concerning probate, trust, and guardianship, and basically estate planning in a pre-death incapacity and post-death planning. Thank you.
We got Jordi.
Yes, good afternoon, guys. Great to be with you. Jordi Guso, class of '83. We were actually the second graduating class from the new school, the new campus. So we got to experience the old Calle Ocho in all its glory and see the new school come together, which is back then is a fraction of what it is today in terms of amenities. So you guys are glad to, or should be glad to have come from that campus. Like Fernando and Sergio, my boys also went to Belen. My oldest, Jake, graduated in 2013. Ryan in 2015, and Kyle, our youngest, is a junior this year. And learning remotely is a whole new experience at the Guso household. I'm a corporate restructuring lawyer. I practice with a firm called Berger Singerman. We're a Florida-based commercial law firm, about 85 lawyers. We have among the largest restructuring practices in the Southeast. And most of my practice involves the representation of troubled companies, both in court-supervised and out-of-court restructuring proceedings. I'm going to talk to you a little bit about that, a little bit about Chapter 11, and a little bit about the Small Business Recovery Act, which is a law that came into effect in February, aimed at streamlining the process for restructuring for small businesses. And I'll talk a little bit about that later this afternoon.
Okay, we have Javier Basnuevo as our youngest and last speaker, but very important topics that he's going to cover.
Good afternoon, everyone. Javier Basnuevo from the class of 2005. I dyed my hair, so it's a little bit darker than everyone else today. Maybe I'm the only guy who only went to the Belen out on 127th, but you know, I have great memories. I love the school and the alumni and everything. I focus my practice mostly on workplace torts and complex kind of torts. I'm in litigation and in trial a good amount. And I also advise employers in, you know, most smaller businesses, but I advise employers on best practices for employment and labor related things in the law. And so I'm going to be focusing today on the changes to employment laws and the ways that employers should be kind of navigating this COVID coronavirus landscape.
Okay, so before we go, and I didn't properly introduce myself. I'm actually also in restructuring, but my restructuring is more. I do marital and family law work. I hope none of you guys need to call me. We have very little time today, so I don't know if we'll get to any topics regarding family law. But so we're going to open up on the business side. We're going to get Fernando to talk about the PPP loans.
Okay. Let me give you a little overview just on the application process, though by now most people should have applied for the second round because they're going to run out of money as well. But basically, it's very simple to get what the maximum amount of your loan could be. You get your payroll for 2019, you get the average monthly payroll, you multiply it by 2.5, you get your loan. The question then becomes, how does it get forgiven? The first thing to consider is what are the types of expenses that will be forgiven. Obviously, your payroll cost is forgiven. That includes wages, salaries, but it also includes premiums that you may pay for health insurance, contributions that you may make to retirement funds, and items of that kind, commissions, etc. So it's not strictly the payroll as it relates to the paycheck for the salary or the wages. It includes benefits. So that's one function of what's forgiven, and that's really the main reason for the loans. It's a payroll protection that is being emphasized, and what's driving the loan. But you're also able to deduct non-payroll expenses, and those would be your lease. It would be interest on a mortgage on the property your business operates out of, utilities, FPL, water, phones. Now, The idea, though, is to favor the payroll. So what you get to do is that you get to deduct from that loan the payroll that you demonstrate, but it's the payroll that you incurred from the date your loan gets funded for the following 8 weeks. It's got nothing to do with when you applied. It's got nothing to do with the covered period. The covered period starts in February and ends on June 30th. But if you got your loan on April 15th, then your period to calculate the payroll that's going to be forgiven is the 8 weeks that follow your funding. And the same is true for your other non-payroll expenses. And also keep in mind that if your payroll happens to fall in the middle of that, you need to prorate it. So if you got a payroll that goes from April 15th to April 30th, but you got funded April 20th, then you need to do that proration and carry it forward for 8 weeks. So basically your covered period is going to be from the time that you get your payroll 8 weeks over through June 30th. Now, your loan amount has very little to do with what is going to be forgiven. The forgiveness is going to be what's called the forgivable amount. And the forgivable amount will be at least 75% payroll, and then 25% of the forgivable amount of payroll will be the second function. So it's not 25% of the loan that you can deduct as non-payroll expenses. It's 25% of the forgivable amount based on your payroll expenses. So it's a little bit tricky. So once you receive the loan, I guess the best way to be able to calculate it, and I will give to Carlos a paper that was put out by Tony Arguisa's firm that helps you with the minutia of the calculations. But basically, let's assume that you have $1 million loan so that the math is easy. If you have $1 million loan, the loan amount, as you calculate, the amount that's forgivable, if you want to take advantage of the other 25%, would be 75% of the loan amount. So that's simple. $750,000 would be your minimum payroll deduction. 75%, if you want to use that, that goes towards your forgivable pile. You then have to figure out what your actual payroll was. So your actual payroll for those 8 weeks is going to be an amount. In my example, if we had $1 million loan, you had a minimum payroll of $750,000 based on 75%. But if your payroll was actually only $700,000, okay, that's going to factor into the calculation of forgiveness, and you're going to be getting already penalized a little bit, okay? So if you follow my example of $1 million loan, if you have $750,000 worth of payroll, you're going to maximize that deduction. If you only had 700, you park that. Then the way that you calculate the 25% of non-payroll cost is that you take 25% of your payroll. So if your payroll was $700,000, you can now spend up to 25% of that $700,000. In my equation, okay, the way you go for it is you get your $700,000, you multiply it by 0.75, that'll give you $933,000. And then you've got up to 25% of that to deduct. So in my example, you would be able to deduct up to $233,000 worth of non-payroll expenses. So now if you had $700,000 in payroll, you could go up to $233,000 in non-payroll cost, your rent, your interest, your utilities. Now let's assume that instead of being $233,000, when you add all that up, it was only $200,000, okay? So now your forgivable amount is $900,000. What does that tell you? That you already have $100,000 that was loaned to you that's not going to be forgiven. That's okay. You got a 1% interest on the loan. You got 24 months to repay it with a 6-month hiatus. So in 18 months, you got to pay that back. But now that's not where they stop. Once you have that forgiveness amount, which is the $900,000 in my example, you're going to get 2 deductions that may apply. One is a reduction of the forgiveness amount by any specific employee that you've hired back, but you've paid him or you've reduced that person's wages by an amount that exceeds 25%. So if you hired someone and that someone in the prior quarter prior to, so let's call it January 1st to March, if that person in your last quarter annualized $100,000, which is the cap, for the math it's easy. If the annualized salary for that person for that quarter was $100,000, and then what you actually paid them between the time that you got your loan and the 8 weeks was only $60,000 annualized, you've obviously paid him less than 75%. So what happens is that you get the difference between what you paid him 60 and the 75%, which in this case is $15,000, and you got to deduct that from the forgiveness. So the forgiveness that we had at 900 now became 855. So one way to get the forgiveness reduced further, okay, is based on lowering the wages or the salary of the person in particular. So if you got 10 employees and you paid them 60% of their wages during the covered period, you're going to be dinged for that difference. Okay, you will not be able to take. You will have a reduction of your forgiven amount by that amount. The other way that could be dinged, for lack of a better word, is if your workforce, as the workforce, also gets reduced. And for that, they have a little acronym which they call the FTE, which is the full-time equivalent. So what you end up doing is a full-time equivalent employee is an employee of 30 hours or more, but you use 30 hours. So if during the period before, all right, we go back to using either January 1st, 2020 to February 29th, 2020, or if you prefer to go back to 2019, you can. You could choose one. But if during that period, let's call it the quarter before, you had 105 full-time equivalent employees, all right, and during the 8-week period that you're trying to get forgiven, you only had 85, okay? If you do the math, that's 81%. So you're going to be dinged 19%. And this is how it goes. You get that $885,000 figure that we had gotten to. Quick revision, it was $1 million. You had $700,000 in forgivable payroll. You had $200,000 in forgivable non-payroll. That was $900,000. You dinged the person and you paid that person 60% of the wages going forward. So you got another reduction of 15. You're now at 885. But if you reduce your workforce by 19%, you're going to end up reducing that forgivable amount likewise. So you would have to multiply the 885 by the 81%, and then the only amount that you could apply for forgiveness would be $716,000. So what I'm trying to get at is that just because you use 25% of the loan, so to speak, for costs that are allowed to be deducted that are not payroll, or if you go ahead and deduct your payroll, you still have two other ways that that forgiveness can be reduced. And that's if you pay the person going forward less than 75% of what that person had made during the January 1st to February 29th timeframe, or if you go to 2019, you pick the one that gives you the better result. You're going to get dinged with that. And then if you reduce your workforce, you're going to proportionally be dinged for that too. Okay, and that kind of gives you an overview of how it works.
Okay, Fernando, you're not going to test us on this afterwards, right?
No, we're not. But what I am going to do is I'm going to figure out with Peps and or Carlos how I could upload to somewhere in our website the Tony Orgiz MBAF pamphlet, which goes into a lot of detail, and it's really very informative. So I'm going to see if I can get that done later. Yeah, so but the idea is that it's got nothing to do with the loan amount, and it's got nothing to do with raw figures of 75 and 25. There's a formula, and unfortunately, that formula can make the forgiveness be a lot less than what you imagine by just using that 75 and 25 number.
Yeah, we'll get that. We'll get that. that. No worries, and we'll send it to them. Thanks, Fernando.
Okay, Fernando, I have a question for you. There's been some discussion on the difference between furloughing an employee and terminating an employee, and what impact that would have on the PPP loan. Can you explain?
Okay, it doesn't have an impact if it doesn't have an impact on the formula that I gave you. If you furloughed somebody in the past or you terminated somebody in the past, that does not influence it. What influences it is what happens now when you receive the money and going forward as compared to the past. So if you had somebody that you employed before and you don't employ now, you're not employing that person. You could have furloughed the person, and Javi will get, Basnuevo will get more into the difference between furlough and the employment aspects of that. But in reality, it's the same effect. If you furlough somebody, all you're saying is, hey, if you come back, you have your job. But you're not paying them in the process, or you're paying whatever you want to be paying their benefits.
Okay, and I got one more thing. I think we discussed the other day when we met preliminarily, that the issue is meeting the threshold, that once you meet the threshold, then you're not penalized. Does that make any sense?
No, it all depends what you call a penalty.
Okay.
Because you always can be penalized. But yes, if you needed the money, you borrowed the money, and you had an active payroll for 8 weeks, then you apply the formula, and you're going to get those 8 weeks of payroll forgiven. Never more than the total amount. And then if you use the formula correctly and you maximize the 75% on payroll, then you've got this other 25% figure that's 25% of the payroll. So if the payroll was 75%, and then you use the other 25% for the non-payroll costs, you're going to get to 100% of your amount. But that's going to be very difficult to happen in reality. What you get penalized for is if you hire someone back, right, and you're paying that person 25% or less than what he used or she used to make, you're going to get penalized on that.
And how about if you add a new employee?
You add a new employee is fine, because that's the workforce. So you have a workforce analysis. So if you had 100 full-time equivalents before, and you have 100 full-time equivalents later, you will not be penalized for reducing your workforce. However, if within that workforce, Javi was paid $100,000 annualized, and after Javi came back, he's only going to get paid $60,000 annualized, you will get penalized for the difference.
All right. I think that was a fairly succinct summary of the PPP loan. I don't know if there's anything else you wanted to add, but if not, we discussed the other day that one of the hot topics on real estate was the clauses in the contracts and the changes in the clauses in certain contracts for the inspection periods, additional time, and then you always have that force majeure contract clause, that is part of some of these contracts that needs particular attention now. You want to elaborate a little bit on that?
Well, if we put the real estate hat on, the Board of Realtors and the Florida Bar have these really good contracts that everybody uses, and now they've come up with, the COVID amendment, which will excuse performance, whether it's at the level of getting your loan, closing the loan, if it is COVID related. So it would be prudent for anybody that's entering into a purchase and sale agreement now that you insist with your realtor or with your lawyer that they add the COVID endorsement to your contract. Otherwise, everything is kind of normal. I mean, you still have to do your inspections. You still have to, get your loan. If you're buying with financing, you still have to close by a particular date, but for excuses. So everything else is normal. Now, because of the fact that everybody's working from home, your bank may take longer to give you the loan. So before you were going to use 30 days to get approved, maybe you want to use 45. The guy that does the inspection might take a little longer. But otherwise, the actual transaction is the same before or after.
Right. So you want to build in additional time for all these contingencies.
Correct.
Okay. If we don't have anything else that you would like to add at this time, I think there's one question that has been posed and says,
Okay.
well, I think you already answered about how if you add an additional employee, have you seen anything that says payroll costs can be more than 75% of the loan amount?
Yes, they can. In other words, the 75% is the minimum amount, and you only feel the minimum amount in calculating the forgiveness if you have less than 75%. So in my scenario where you had 700,000 instead of 750,000, that 50,000 that you were short ends up, as you would call it, being somewhat of a penalty at the tail end. But if you have more than 75%, you can still take that under the forgiveness formula. What it'll do is that you're going to have less money to use for the other expenses, meaning your lease or your interest on your mortgage or your utilities. But the more you use on labor, on the forgiveness side, the better you're going to be.
Okay, thank you, Fernando, for that. If we're gonna switch over to Sergio Mendez, class of '77. He previously introduced himself and his firm that handles probate and estate matters and estate planning, and he is going to talk to us about estate planning and issues of incapacity during this time.
Thank you, Javi. As we've seen, and unfortunately, it's come to the forefront that during this crisis, people dying and people getting sick, and now hopefully we're thinking more about planning. And I don't like to call it estate planning because people think that if I don't have significant assets, or if I'm not old or enough, I don't need to do this, and that's a very costly and popular misconception. I think we all need to do some planning for our families to guarantee that we have a proper process and we can lighten, let's say, the load with respect to the stress that's related to this process when someone becomes sick and becomes incapacitated or passes away. We frequently think about planning in terms of death planning, but I think it's even more important to plan and have the proper documents in place concerning an incapacity. People can be incapacitated for a number of years. They need to be taken care of, and if they don't have the proper documents in place, it can certainly create a lot of problems legally as well as for the family, is how to deal with the situation. So in terms of planning, we draft and recommend a designation of healthcare surrogate, where you designate your surrogate, the person who's going to make healthcare decisions for you in the case that you've become incapacitated. A very important document to have. Also, a durable power of attorney, someone that can act on your behalf if you're incapacitated. This power of attorney is a durable power of attorney, so even if you're incapacitated, it still works. This person can act for you. The durable power of attorney can be limited to basically you signing contracts or financial matters or health matters, but another very simple document, but very necessary to have. Another one is they call a living will, which really the title doesn't really tell you exactly what it is. It's basically you electing whether you want to be kept alive by artificial means, or rather whether you want to be disconnected and not used artificial means to keep you alive. There can be time periods that you designate in the document for that process to take place, and designate an agent. Additionally, if you become incapacitated, you may need a guardian to manage your affairs. There's a guardian of the person and a guardian for your property. So you could designate before your incapacity who would you like that person to be. It not always is a spouse, it can be a brother. The designation of the agent is critical. You can draw beautiful documents, but you don't have an agent that knows what they're doing or is willing to do it or is honest enough to do it, then that's where the problem arises. So that planning to contemplate an incapacity is critical, and it's really for the benefit of your family to make that planning. I think it's essential. Another type of planning, which a lot of people don't do, is designation of beneficiaries. It's very simple. A lot of times we open a bank account or we open a company and take shares or units in an LLC or any type of asset, and we don't consider designating beneficiaries. And I can tell you, even this esteemed group here, if you go back and you put together your personal financial statement, I bet you that we all will find that there's some asset that we haven't designated a beneficiary to, especially units in a company or shares of stock in a company that we may be involved in. It's a very simple planning tool, which would obviate the need to have to probate that asset. So that's always good to consider. Another planning tool, which is quite simple, is what we call a life estate deed, an enhanced life estate deed, more commonly known as a Lady Bird deed, after Lady Bird Johnson, the wife of the former president. In that deed, you give yourself, if you're the owner of the property, you deed yourself a life estate, so you own the property for life. You can enjoy all the benefits of the property. You can retain homestead exemption if you had it. And if you reserve your powers, you can even revoke the designation to a remainderment. So what does this deed do? It basically passes the property to your remainderment at your death. And you can revoke it if you choose to change your remainderment. It's a very simple deed, and it obviates the need to have to go to probate to transfer the title of that real estate property if you do a deed in that fashion. Probate, a lot of people are looking now to do wills, to do trust, to take care of their assets once they pass away, as far as who's going to administer these assets, how they're going to be transferred, are they going to be in trust for the benefit of a family member or a friend or a charity. A lot of that planning should be done to avoid probate. Probate is a costly process, and if you don't have the proper documentation in place, it could lead to really a lot of ugly litigation. I think the litigation that we handle is similar to Javi's litigation, in the sense that it's families, it's stepmoms and stepchildren and brothers and sisters, and it's ugly, and a lot of it could have been avoided with proper planning and properly drafted documents. So unfortunately, we're in times that of what we're suffering now, but it brings it to the forefront of the real critical need to plan and to have your documents in place, and to go back and examine your assets and see if you in fact have designated beneficiaries and you have the right documentation in order. It's a good time to review it and make sure that those type of things are in order, and to save your family the stress and the headache of when you're not able, if you're incapacitated or you're not with us any longer, that your affairs are in order and are processed properly without stress.
Okay, Sergio, thank you for that. And regarding the designation of beneficiaries, at least in my line of work, one of the things that people forget to do is once they get divorced, they forget to change their beneficiaries. And sometimes you have a situation where a former spouse is still listed as a beneficiary, which is obviously not what you want to do. So for those of the listeners that have been divorced and haven't changed their beneficiaries, that's something that they should look into. I think we talked with you the other day in preparation for this conference, and you brought up a good point regarding the landlord-tenant situation and the terminations and what's going on with the governor, and that there may be some misunderstanding as to what possibly landlords can do and not do with these administrative orders or executive orders that the governor has put in place.
The governor's order, and there are local orders by the mayor of Miami-Dade County, but the orders that are in place prevent evictions, and really the Miami-Dade County mayor has the ability to stop the Miami-Dade County sheriff from evicting people. But people are traveling on a misconception that they don't have to pay their rent and that they're not going to be sued at some point to be evicted. The law still permits termination of leases by means of a default letter pursuant to a written lease, or if you have a residential tenancy and you don't have a lease, by means of a 3-day notice to pay. And if the rent is not paid within the 3-day notice after service, then the lease is voided. So those are preconditions to having the ability to sue. No one can start or initiate an eviction proceeding presently, but you can be prepared to file a lawsuit for eviction if necessary by having examine your lease agreement and see what the default remedies are in the aspect of notice. And in the residential side, if you do not have a lease, to file, send a 3-day notice to pay rent. And basically then once you've done that and they haven't paid rent, then you're ready to go ahead and file an eviction proceeding. But there's a popular misconception that you can't do anything to protect your rights as a landlord right now, that everything is frozen and that people don't have to pay their rent. That is certainly not true.
Okay, thank you, Sergio. And up next, we have Jordi Guso, class of 83, with the firm of Berger Singerman. He introduced himself previously. He is a corporate restructuring specialist and very familiar with the topic of bankruptcy. He is going to talk about some topics since this COVID-19 is affecting our entire economy. So, Jordi, you got the floor.
Sure. Thank you, Javi. And so as this pandemic started to affect the U.S. economy, we encouraged all of our clients to shore up their liquidity. In times of crisis, liquidity is king. And among other things, we encouraged clients to look at their credit agreements and, where available, draw down on the credit lines to create cash reserves. You may remember in early March, United Airlines drew on its $2 billion credit line as a way of shoring up its liquidity. A week later, Boeing drew down on its $13 billion credit line. That dynamic was not unique to Fortune 500 companies. Middle market and lower middle market companies, likewise here in our local community, looked at their availability and tried to create liquidity by drawing down on their credit lines. We also encouraged our clients to look at other material contracts to determine which obligations could either be pushed off or restructured, again, with the aim of preserving cash, which, as I said, is king in crises like these. And one common dynamic that we observed prior to PPP was tenants, particularly those that operate in the retail sector, approaching landlords asking for either rent concessions or rent abatements. And frequently the trade was, hey, give me free rent for a couple of months. Typically the landlord granted some form of accommodation in exchange for an extension on the lease term. So if, by way of example, the landlord agreed to a rent abatement for 2 or 3 months, the term of the lease would be extended by 2 or 3 months, so that economically in the long end, it was a wash for the landlord. That dynamic has changed a little bit in the post-PPP environment. As Fernando observed, up to 25% of loan proceeds can be used for non-payroll expenses, including rent. And so now you're seeing landlords ask tenants whether they applied for PPP loan proceeds, if so, how much they received, and what they intend to do with the proceeds. So that dynamic has changed a little bit there. In addition, on the lender side, about 3 weeks ago, the FDIC issued some guidance to federally insured banks, requesting that banks work with their borrowers in the event of a default before exercising rights and remedies. Of course, 2 things you need to keep in mind. One, it's only guidance. The banks aren't required to follow the guidance. they can use their own discretion and not extend accommodation. And secondly, the guidance, even if it applies or observed by the banks, doesn't apply to non-federally insured lenders, non-institutional lenders, particularly if you have a securitized loan. Special servicers and servicers are not required to honor that guidance, and they're also limited in what they can do in terms of restructuring the debt because of the way those arrangements work. They're typically tax-free, so the servicers are very hampered in terms of what they can do by way of a restructuring or financial accommodation. When we're representing a troubled company, our preference is by a wide margin to first try and pursue an out-of-court restructuring and avoid a filing. Obviously, working through a troubled situation consensually is much more efficient, less expensive, and generally quicker than an in-court restructuring. But if the circumstances don't permit an out-of-court restructuring, or if there is a strategic reason for a company to file, then typically the filing occurs through Chapter 11 of the Bankruptcy Code. Chapter 11 is the reorganization chapter of the Bankruptcy Code, not a liquidation. In that proceeding, management of the company retains control of the business and its operations. It now acts as a fiduciary for all of the company's creditors, but they are not displaced by a trustee or other fiduciary. Chapter 11 obviously gives a company a breathing spell from its creditors. Litigation claims come to a halt, and creditors are enjoined by statute from taking any action against the company or against its assets. The company has an exclusive period of 120 days within which to formulate and propose a plan of reorganization. And the plan is essentially, if approved, a legal contract between the company and its creditors about how it will address its liabilities, how they will be restructured. And often the plan includes not only deleveraging of the balance sheet, but also some component of an operational restructuring. A retailer, by way of example, may close down and get out of the leases for underperforming stores or operations that no longer are profitable. Chapter 11 is a really powerful tool. You can do a lot of good things in Chapter 11, but it is also cumbersome. Generally, the process is better suited for middle market and larger companies, not small businesses. It's expensive. By way of example, the filing fee for Chapter 11 alone is in excess of $1,200 for each company that you file. So if you have more than one company, that fee is applicable to each of the companies that would file. There is lots of financial reporting that comes with Chapter 11. Obviously, the court and creditors have an interest, vested interest, in seeing how the company is performing. And so there's an obligation to provide monthly financial reporting to the court, which again can be cumbersome and expensive. And any action that the company wishes to take outside of the ordinary course of business requires court approval, which means that there has to be a motion, there are hearings, go to court, all of which obviously costs money. In larger cases as well, the Department of Justice, through a wing called the United States Trustee, who's charged with overseeing Chapter 11 cases generally, is authorized by statute to appoint a committee of creditors. The committee is usually comprised of no less than 3, no more than 7 creditors of a company, and the committee acts as a representative of the creditor body as a whole. The committee has the right to appear and be heard on any matter in the case. It's got the right to retain professionals. The cost of the committee and its professionals is borne by the company. That's an added expense, but the committee can add a whole lot of value to the restructuring process, particularly if you engage in principal negotiations regarding what the company needs in order to restructure and ultimately survive. The name of the game is to preserve going concern value, recognizing that in liquidation, creditor recoveries are going to be substantially less. Obviously, you're going to have a loss of jobs. And so the objective is to try and preserve value through a financial restructuring or reorganization. Things got a little better for small businesses in February when Congress passed what's called the Small Business Recovery Act, which is now a subchapter of Chapter 11. It's subchapter 5. It was intended to streamline the process for small businesses. As initially enacted, the Small Business Recovery Act was only available to companies who had $2.5 million or less of debt. Part of the CARES Act, which led to the PPP program, raised that debt limit from $2.5 million to $7 million. So now that if there's a company that has $7 million or less of debt, it is eligible to file under subchapter 5. Under subchapter 5, there is no committee. It's a much more streamlined process. There is no financial reporting. There is no requirement that priority claims get paid in full when the plan is approved. There is no solicitation of creditors, meaning that creditors don't get to vote on the plan. In a typical Chapter 11, the company distributes its plan of reorganizations to its creditors, and creditors have the right to vote on it. Here, only the court assesses whether the plan is fair and equitable. And for purposes of that analysis, the court simply determines whether the company has committed to providing all of its disposable income over a period of no more than 5 years to address the claims of its creditors, and that the plan provides more to creditors than would be available if the company were liquidated. So for small businesses in particular, this is, I think, a tool you're going to see utilized quite frequently in this unfortunate crisis. But it's a great tool for those businesses.
Okay, Jordi, well, I'm going to summarize it real quick. The key, gentlemen, is to stay out of Jordi's office.
Listen, one man's misfortune is another man's opportunity.
Yes,
there are also opportunities in the professional world.
Well, and I also say, it also goes to say that you stay out of my office too. It's not a good thing if you're seeing Jordi or myself. So
there you go.
Now and before we move on to our last speaker, who is got a lot of different topics that he needs to cover, just to remind you guys that we are fielding questions. I believe that Carlos, do you want to chime in a second? Make sure, I think they can do it through the chat. Through the chat mechanism in the Zoom, but we are fielding questions. I believe we had one question about, let me see if I can get the question, which was, during this time, do you still have to send tenants the 3-day notice, which I believe Sergio answered that yes, you do need to send the notice. You just want to you want to send the notice so you can be in a position so that when you can file your eviction action, you've already complied with what you need to do. Correct, Serge?
Yes, sir. Notice requirements.
All right. And Carlos, you want to chime in with anything?
No. Right now, I've been sending the questions to Fernando, to you, and you guys have been doing a good job on grabbing them. So Fernando has one there.
Yeah.
Okay, perfect. So you're sending the questions to the speaker as they are.
Correct. And if Fernando has one, I think to answer that.
I have one. I can answer it now, or I can let.
Well, you have the floor. So take it.
Go. Yeah, there's a question. When you apply for the loan, there's a certification you have to make that says that under the current uncertainties, it makes this loan request necessary. So some people are concerned, maybe someone has a relatively good office, they're not starving, they're not in the brink of bankruptcy. So how do you judge if the request is necessary? And the key is the current economic uncertainties. Because there is so much uncertainty, you use the uncertainty as the basis for the request being necessary. So it's not a difficult threshold. You could certify that because of the uncertainties, you feel it's necessary to apply. But that's what you need to certify.
Okay.
But it doesn't mean that you're going to be broke, destitute, and can't find your next meal.
All right. Well, now we are now introducing Javier Basnuevo, class of 2005, and he's got a bunch of topics to talk about labor and employment. business interruption, severance package, COVID-19 benefits. I'm sure he's got a nice laundry list of things that he wants to share with us.
Yeah, and hopefully it won't be too long, but I have basically 4 topics that I wanted to discuss with everyone. And that's the first thing is the amendments that have been made to the Family Medical Leave Act. That's the law that lets you take leave from work if you're sick or if a family member is sick. The second thing I wanted to talk about is what's the difference between furloughs and layoffs and how those can affect severance and severance package and benefits. I want to talk about, testing. As businesses start reopening, what do you do if you're a business owner and you want to test your employees? And what do you do if you're an employee and you feel uncomfortable with certain testing? And the last thing we want to talk about is the business interruption, or it's really called business income insurance, and how that applies in this case. Well, the FMLA is really a law. It's the Family Medical Leave Act, and it's the law that allows an employee to take up to 12 weeks of unpaid leave work and then come back and have your job held for you if you can't be at work for a medical reason. And that's been amended in 2 really important ways here for the coronavirus. The first is the child care amendment, and that is if you are unable to work because your children's school has been canceled and you're the primary caregiver and you need to be taking care of them, you can apply for up to 10 weeks of paid leave at 2/3 of your regular salary. And that 2/3 is capped at either $200 a day or $10,000 total. So if you have trouble going to work because your children's school is canceled and you need to be home taking care of them, you are allowed a partial pay up to $200 a day and $10,000 total. Now, if you're an employer and you have someone who has come and has requested that kind of leave, that pay that you have to give to them, the $200 and the $10,000, is then applied as a tax credit to your to the paycheck withholding, to the taxes that you got to pay as a withholding. That's credited at the end, so you get that money back later on in the year. Another change in this law is that normally the law applies only to rather large employers. That's employers that have more than 50 employees in a 75-mile radius. Now that's been changed. It now applies for these COVID, specific little COVID carve-outs. It applies to any employer that has less than 500 employees. It doesn't apply to employers that have more than 500 employees, which is kind of a strange little hiccup in the law. The other issue is that if you have coronavirus, or if you're under a quarantine order or a stay-at-home order and you can't go to work, you're now entitled to up to 80 hours of full pay leave. And so if you get sick, or if a spouse or a close family member gets sick and you need to stay home, you have 80 hours of leave. And there are some criteria on this, and that's that you're either subject to a federal, state, or local quarantine or shelter-in-place order, if you've been advised to self-quarantine by a doctor, or if you're experiencing COVID symptoms, you let your employer know and you get up to 80 hours of full pay. As far as employers, there's an important additional requirement to the law, and that's that you post notice of these changes. And I think the Department of Labor, if you go to their website, they've got like a form notice that you can print out and put in a conspicuous place. If you're an employer, you have to post this notice. And, people now, they're losing their jobs. They're a little bit hungry for money. So you don't want to expose yourself to an unnecessary lawsuit for failing to post the requirements of this law and having somebody come up and say, oh, I didn't know that I could take this leave or whatnot. So it's important that you, post notice, go up to the Department of Labor, and I can send Carlos the link to one of the notices so we can send it out afterwards to everyone. Just print it out, put it in the break room, put it anywhere that's a conspicuous place, and that will insulate yourself from, that kind of a lawsuit. The other issue that's, I think, been coming up a lot is employees have been told, all right, you can take some time off, but you need to find somebody to replace you in this time. You may have some child care obligations, you may be sick, but find somebody to cover your shifts. That's illegal under this new law. You can't require an employee to find their replacement or to get a replacement before they're entitled to leave. They're entitled to leave no matter what, and you can't, require them to find a replacement. And then the third thing, and the third change to this law, is that normally under the FMLA, if someone wants to take their leave, you can ask them to take their paid vacation time that they've accrued either before or concurrently with their leave. And now that's been changed. If someone's going to take coronavirus related leave, you can't ask them as an employer to dip into any of their other accrued time. Either if they've got some other disability leave benefit, or if they have accrued vacation time, it can't run concurrently and it can't run before. They must be entitled to take this new FMLA leave before they dip into any of the other time that they've got available. The last major change is that under the previous version of the FMLA, an employee had to be working for an employer for a 12-month period before they were entitled to take leave. Now, if it's a coronavirus-related reason, they only need to be working there for 30 calendar days. So a lot more people are now going to be eligible to take this kind of leave because it, again, covers everybody that's under 500 employees and any employee that's been working there for more than 30 days. If there's a coronavirus-related reason for leave, you got to give it to them. And you got to post the notice of the leave. Those are the changes to the FMLA, and that's what people are talking about, the Families First Coronavirus Act. That's the stuff that's in the Families First Coronavirus Act. The other topic that we wanted to talk about is, what's the difference between a furlough and a layoff, and how does that affect, both the employees and the employers? Essentially, a furloughed employee is an employee that still works for you, but you're not paying them because they're not performing any labor. And a laid off employee is someone who, no longer works for you. The employment relationship is completely severed. With a furloughed employee, you're still contributing as an employer. You're still contributing to their, their group health benefit plan. You're still entitled to contribute to their 401k plan. If there's disability plans, those kinds of things, that contributions are still happening to those plans. If an employee is also contributing to those plans, either through a 401k or they're contributing to their own health insurance because they're paying for that, normally that kind of stuff will just come out of their paycheck. It'll be deducted from their paycheck, and when you pay them, there's that amount less. Now, if they're furloughed or if someone's not working, they can still contribute to those plans by paying directly. So you want to take a look at your plans and see exactly what the terms of health insurance or 401k plans are to make sure that, some of them have requirements that the employee be actively working in order to contribute. Some of them allow a furloughed employee to contribute and still get health insurance. So if you're an employer, you want to look into that. If you're an employee who's been furloughed, you want to ask really pointed questions about exactly what's going on in the plan. Can I still contribute? Mostly these kinds of plans, it's a lot better than if you're going to go through COBRA and, buy insurance out in the marketplace. You can get much better coverage if you go through your employers. So, keep a lookout for if you're furloughed or if you have to furlough someone, remember that those contributions are still occurring for the benefits. Now, if you are laying people off and you want to offer them severance, a lot of times in Florida, at least, employment is what's called at will, which means you can be fired for any reason, for no reason, as long as it is not a discriminatory reason, you can be let go. And so in a severance agreement, there's really no right to severance pay. And in Florida, there's also no right that you be paid out your vacation time if you're let go. All of that is entirely up to the employer. If they want to give it to you, great. If they don't want to give it to you, that's really unfortunate. But in severance agreements, usually the employer will ask for concessions when they're let off. And those concessions can take the form of signing a release so that if you're sued for anything in the future, releases, and signing confidentiality and non-compete agreements on the back end. Some employees that maybe you didn't give them a non-compete agreement when they were working for you, but now you want to lay them off and you want to make sure that when things start opening up, you don't want to have them competing against you in the new marketplace. Well, you can, put in a non-compete agreement into the severance package and pay them something in exchange for that benefit that you're getting from them. Dealing with releases in a severance package, you got to be careful, because some things like disability claims, discrimination claims, discrimination for disability claims, unpaid wage claims, those things can't be released. Some of them can't be released without court approval. Some of them can't be released without waiting periods. So usually you'll see in those severance packages, employees will be given 21 days to consider the package, or 7 days from the day of signing for it to become effective. So if you're thinking about having an employee sign a severance package, or if you're signing a severance agreement yourself, you really want to get a lawyer to look at these things individually to make sure that the terms of the agreement are compliant with the law. But generally, you don't have to get severance, and you don't have to give severance if you're laying someone off. It's only if you want some sort of exchange on the back end of the employment relationship. I got to know, there's a question here about how do we post notices if you're in a remote environment? Do we need to send emails? The answer is yes. The guidances say that, if you're in a remote environment, sending out an email blast to employees is the correct thing to do. If you're having employees come in to a physical workplace, then putting it in a conspicuous spot where everyone will see, someplace like a break room, a coffee room, right near the entrance, right near where people check in. If there's hourly employees, have them check in that way. If you're in a remote environment, the answer is send an email. As things start opening up, there's a question about testing, and can you test your employees for coronavirus? That starts to implicate the ADA, and the answer is yes, you can test your employees for coronavirus. You can take their temperature as they come in, as long as these things are necessary because they're job related and they constitute a business necessity. Now, the Department of Labor, again, issued some guidances about this, and what they say is generally, we want to promote safety in the workplace. We want to make sure that our workforce is pandemic free. And so basically every business has a free pass with saying it is business related to test my employees, and it's business related to take the temperature of my employees. What you cannot do under the law is start sharing the results of those tests and start sharing the results of the temperature checks with other employees. Those tests and those temperature checks are considered a medical screening, and medical screenings need to maintain confidentiality. I can see there's a question about the FMLA. Yeah, there's a sunset provision in the law. It's going to, I think it's right now set to expire at the end of this year. It may be renewed, it may not be renewed, but right now it's set to expire at the end of the year. So after the end of this year, those additional FMLA requirements are not going to be available. With the testing and asking people to take tests before they come into the workforce, very important that be applied in a non-discriminatory manner. You don't want to test people from, certain national descents more than others. You don't want to test people that, if you're going to test, you have to test everyone. Make sure that there are business reasons the way you're applying the tests. Maybe you're not testing people who are working from home, but maybe you're testing everybody who needs to be coming in to be physically present in your location. Just make sure that it's tied to a business necessity and that you can't have anybody come back and say that these tests are being applied in a discriminatory manner or being used as an excuse to discriminate against someone. The easiest way to do that is just make sure that things are applied categorically across the board. See if I wanted to talk about anything else.
Got a question for you. What if you are in a non-essential business and you want to try to require your employees to come back before this safer at home order is taken away?
Well, the clear answer is don't do that. Don't do that. If you're a non-essential business that's been banned by one of the orders, either the Dade County one or one of the local city ones, and says you can't open, don't open before that order gets gets opened up. There are laws in the state of Florida that give local governments the power to either close or suspend businesses when there's an emergency. I think that basically every municipality and county in South Florida has declared a state of emergency, and so these local governments have the authority to close non-essential businesses. So don't come back before local governments tell you you're allowed to come back. Now, when they tell you you're allowed to come back, if you want to do some testing, just make sure that it's across the board and the results of the tests are kept confidential from other employees.
Okay, what if you're in a non-essential business and you have an employee that wants to come back? You're not asking them to come back, but they voluntarily want to come into work because they're tired of being at home with the kids and the wife and all that kind of stuff, and they'd rather come to work.
I mean, the short answer is don't have anybody come to work if it's in violation of one of the local orders. That's, even if they want to come back, even if they're clamoring to come back, if the local orders don't allow your business to reopen in the physical location, don't have them reopen. Now, that doesn't mean that you can't be teleworking. That doesn't mean that you can't be selling your products over the internet. Just don't have people come to physically work if the local ordinances are not suspended.
Javi, what are the consequences if you open and violate that order?
Off the top of my head, I don't know the consequences. I know that there's fines, and then if you do things knowingly, there's jail time for the managers of the companies, but they're found in the laws that govern a state of emergency in Florida, and a lot of that, ties in with stuff that happens during hurricanes, with the price gouging and the authority of local governments under hurricanes.
It just appears that there's a bunch of orders out there, curfew orders and stay-at-home orders and non-essential business closing orders, but the consequences for violation of those orders are not clear. And I think people are sensing that there's no teeth behind these orders.
And part of it is that they're not really being enforced all that strictly. I don't think that anyone's, any enforcement authority is really chomping at the bits to put people in jail or to, have fines. But, there could be liability if you're a non-essential business and you order your employees back to work and everybody gets sick, you may be facing some trouble there. So my advice is don't do it. But, if you're trying to do it, I think teleworking and staying at home is probably the best bet for something like that. And then the last thing I wanted to talk about, it's been a kind of a hot topic lately, and that's this business interruption insurance. And it's really called business income insurance. So if you have what's called a business owner's insurance policy, a lot of businesses have that. It's this kind of stuff that covers damage because of theft, damage to your computers. Some of it is kind of like comes into damage to property from hurricanes and stuff like that. In those kinds of insurance policies, there is usually a clause which allows you to recover lost profits if your business needs to be closed for whatever reason that's outside of your control. Now, the individual policy language is going to govern that. So it may be that your business, it may be that your policy is pretty broad. If you've paid for a really good policy, it may be that you're able to recover for lost profits on this thing. It may be that there are some exclusions. The usual exclusions for this kind of thing really does include a virus. So usually in this situation, there will not be coverage for business interruption because usually policies will exclude a business interruption because of a pandemic or because of a virus. The difference is that a lot of times these policies exclude coverage because of a virus, but include coverage if there's a government order that says you must stay at home. So a lot of people have been making claims under that, hey, my business isn't really closed because of the virus. My business is closed because there's that stay-at-home order. The local government doesn't let me open. I've been deemed non-essential. And so there may be coverage in that case. I asked one of my good friends, Brian Costa, who's also a Belen alumni, to kind of explain this to me. And he walked me through some different scenarios where this could be applicable. But essentially, it comes down to what is the language in your policy. So if you think that you have a business owner's insurance policy, or if you're the kind of business owner that has a lot of insurance, it's important to contact your insurance agent. Ask what kind of a policy you have. Ask what that covers. Ask to see the policy so you can make a determination, because if you've been ordered to be closed as a non-essential business, you may be able to recover insurance benefits because of it.
Okay, gentlemen, in a minute, I'm going to ask our panelists for their final thoughts, if they want to add anything that has been discussed during the meeting. I have one question, and Mr. Pat Collins, who's graced us with his presence, has posed the question. Several corporations that received PPP loans have announced that they are returning in good faith the loan. How did the LA Lakers receive a PPP loan in the first place? Well, we know that Shake Shack returned the money, so we should give them a little bit of business. Does anybody know anything about the Lakers?
I don't know about the Lakers.
Something to dig up. All right. And before we go to the final thoughts, as you guys know, I'm a marital and family lawyer. Like I said, hopefully you guys never need to call me for anything. Issues that have come up, some of you guys may be divorced and have issues. We got time-sharing issues. We've had a lot of time-sharing issues during this period of time. People that have not returned their children to the other parent. There is an administrative order out there that does not allow that. You are supposed to honor your time-sharing agreements and your parenting plans during this period of time. And there is no basis for withholding the children from the other parent. And for some of you that have been affected by this financially, not that I'm trying to drum up any business, thank God we don't need it, but keep in mind that there are modification actions. You can file a motion to abate or to suspend your support obligations if you are unable to meet, if you're unable to pay them at this time. And what's important is the longer you wait, the longer you owe. So if you have a support obligation and it is due and you do not pay it, that support obligation accrues and becomes a vested liability. If you need to seek relief, the sooner you seek relief, the court can only go back retroactive to the time that you filed and your motion or your petition, typically a petition for modification or some kind of petition to modify or abate or suspend your obligation. Until you actually file something, the court cannot give you relief and you cannot go back retroactively. So keep it in mind. I don't want the work, just I want to save you guys some money, and keep that in mind for those of you that need to seek that relief. Any final thoughts, Fernando?
No, I'm good.
Okay, Sergio?
Do your homework, go examine your designation of beneficiaries, and I'll guarantee that there's something out there that you haven't designated.
Jordi?
Be proactive. I think the PPP program helped kick the can down the road for some businesses. Start thinking about what your business looks like at the end of June. It may be that we're not completely out of this mess by then, and don't wait until the crisis is before you. Plan ahead.
Javi B?
My final thoughts are, as an employer and as an employee, is treat others the way you want to be treated. If you're an employer, don't require people to come in if they don't really feel comfortable. And if you're an employee and if you're sick, stay home. The laws are meant to protect people, but if we all just act with a little bit of common sense, I think we're going to get through this one.
Okay, Carlos is going to jump in for a minute, but before we go, just as a reminder that we started this at the beginning of our presentation. Gentlemen, we got to put in a general disclaimer. Obviously, this presentation is for informational purposes only. You need to consult your appropriate lawyer for the appropriate legal advice. This is all new cutting edge issues and topics. We don't have all the answers. We can identify the issues for you. But, if you got any questions, contact your favorite lawyer and take it from there. There's a survey, I believe, that the school wants you guys to fill out about the presentation. Carlos can talk a little bit more about that. And gentlemen, stay safe. More importantly, stay sane.
Thank you, Javi. Thank you, Javi. You did a wonderful job. To all four of you panelists, Javier Basnuevo, Fernando Aran, Javier Perez-Abreu, Jordi Guso, can't thank you enough for what you provided for us today, the information. We will get that information out to you as I get it. So that would be so we can send it to you. And yes, we do have a survey which Jose Lopez Varela is going to put out here right now. And once again, if you can do this, it'll be great. And thank you all. Thank you, Jose Lopez Varela, for helping me out. And again, the panelists. And stay tuned for our next AVE next week with the accounting individuals. So thank you.